Equal Opportunity at Iowa State University. I'm also ISU's Senior Deputy Title IX Coordinator. I appreciate you all being here today. Thank you for the invitation. Thank you for the time. You know, as we all were arriving in the room, I was just reflecting on what a moment we're in. I had the opportunity to speak with you a little bit over a year ago, and it's such a moment and it's so challenging for so many folks. And I really want to acknowledge that as we enter the space today. So again, thank you for the time. I'd anticipated talking for maybe 40, 45 minutes and then having Q&A at the end. However, should you be so inclined, I welcome questions as we go along. I understand that Brock is going to be doing the screen sharing, and then I'll let you know, Brock, as we're moving forward with slides. So the plan for today is I'm going to, our discussion today is about sexual harassment. And usually in these discussions, we kind of go through the law, and then the last thing we talk about is kind of the consequences or impact of sexual harassment on the workplace. I want to begin by talking about that. Like, why does that even matter? And why are we taking the time to talk about this today? Because it's not merely checking a box, right? Like, it really does matter. We're talking about harassment generally. So we'll talk about that first. Then we'll talk a little bit about the law. I'm going to talk briefly about Title IX. I understand that several of you may have attended a recent presentation by the Title IX coordinators at the Regent institutions. But I also understand that some of you didn't. So I'm going to go ahead and give you kind of the big picture of the Title IX changes because it has such a significant impact on our institutions. And I'll talk briefly about Title VII, a little bit about Iowa Code, and also about Board of Regents policy as well, and kind of how harassment, and in particular sexual harassment, what that looks like in these different spaces in the law and in our policy. Then we're going to talk about what sexual harassment actually looks like. To help us be able to address, like, identify it, and then what do we do when we see it? What are some good procedures and best practices in terms of engaging it? And then I'll end our conversation today by talking about kind of our responsibilities to really prevent and address harassment in the workplace, again, in particular, sexual harassment. Brock, if you were there, I'm not seeing screen sharing yet. I'm happy to share my screen if that would be appropriate. There we go. Thank you so much. So we can go ahead and go to the next slide, please. And this is our menu. So this is what I just said. We're going to talk about harassment, discrimination, look at a little bit at law and policy, be able to identify and respond appropriately to it, and then talk a little bit about rights, responsibilities, and resources. You can go to the next slide, please. So this is kind of why we're here, right? Like, why are we talking about this? As I said at the outset, we are also in a particular moment, right? Folks are feeling really vulnerable. Folks are just having a lot of different sorts of challenges. Employees are, students are, it's a moment. So there's reasons why we want to be attuned to what harassment is and why we need to think about it and attend to it, because it has consequences in our workplaces, right? We often talk in the work that we do in Equal Opportunity at Iowa State about intent versus impact. So some of the behaviors we'll be talking about today, such as like touching someone or giving compliments or making statements, it can often come from a good intent. I mean to give a compliment. I mean to demonstrate that I think you're doing a good job, or mean to be supportive. But we really need to consider the impact on folks about what we're going to call harassing behaviors. In the work that we do in Equal Opportunity with employees and with students, we see all different kinds of harassing behaviors. Things like statements, compliments, touching, images, this kind of stuff that we'll talk about today. And whether it's actually discrimination or harassment under the law, or whether it's just what we might call bullying or threatening behavior, it has an impact on folks. So there's well-documented workplace outcomes, right? If folks are feeling uncomfortable, if they're not feeling safe in the space, if they're feeling that they're being harassed, they won't go to work. They won't go to class. They won't be as productive, right? And it impacts their relationships. It impacts the workplace. And it also has these personal impacts on folks as well, right? So mental health outcomes are very well documented. Physical health outcomes are also documented, right? And just quality of life issues. People can feel isolated. They can feel alone. They have trouble sleeping. It can really kind of be these global consequences. So when we think about harassment and sexual harassment, and in the midst of a pandemic where folks, their workplaces are already different, right? The school situation's already different. It really can amplify impact. And I would also note at the outset that the fact that a lot of folks are working and doing school from home, the nonsense continues. Bad behavior continues. It happens virtually, it can happen remotely, it can happen in all kinds of non physical spaces. So it's an important conversation to have, and I look forward to talking with you all as we go along. Next slide, please. So discrimination and harassment have a very particular definition, and it's important for us to distinguish that some things that people might think are harassing are in fact not harassment, but might be bullying, right? So one of the takeaways from our conversation today is for you all to know what discrimination and harassment are and how that is different from, distinguished from, like bullying or other threatening behavior. So discrimination is adverse treatment based on an actual or perceived protected status. When we're talking about protected status, here we can turn to Iowa code. And in Iowa, these protected statuses, or what are sometimes referred to as protected classes, include age, color, creed, familial status, gender identity, marital status, mental disability, national origin, physical disability, race, religion, retaliation, sex, and sexual orientation. You can find this in the code, and you can also look at the Indiana Civil Rights Commission also offers some really good information about what the protections are for the different protected status based on what the status is. So for our conversation today, when we're talking about sexual harassment, in particular, we're talking about harassment on the basis of sex, which includes sexual orientation and gender identity. Harassment is a kind of discrimination. So discrimination is like the umbrella, and harassment is a kind of discrimination. And regardless of kind of what policy or law you're looking at, it really boils down to an unwelcome behavior based on an actual or perceived protected status that is sufficiently severe, persistent, or pervasive to unreasonably interfere with employment or education or access to those. So you'll see as we're going along that there's some threads that are similar when we're talking about Title IX, Title VII, Iowa Code, board policy. It really refers to this unwelcome conduct that is severe, pervasive, and has this impact on the individual's access to employment or education. Next slide, please. So I'm just starting with Title IX to just kind of go ahead and get it out there. And as you may all know, there were substantial changes to Title IX this summer. Title IX is the federal law that prohibits discrimination on the basis of sex in education. So on May 6th, we were notified that there were changes to forthcoming changes to Title IX that went into effect on August 14th of 2020. So for all of the Regent institutions, for institutions across the country, and this is for K-12 and for higher ed, we all had to really attend to our policies and procedures to make sure that we were in compliance. So I'm going to talk very broadly today, but I'm happy to also talk about Iowa State if you would like us to kind of dig deep down into how we're addressing these things at ISU. The main changes, very broadly speaking, are Title IX now has kind of a narrower definition for what is included in Title IX, and that has implications that we'll talk about. Title IX can also be understood to now have kind of a more limited scope, which we'll talk about. And as a result, there are also changes to both investigation and adjudication procedures that were outlined by the new regulations and then are implemented at the Regent institutions and at all educational institutions. Next slide, please. So when we're talking about the definition, at Iowa State, we all had previously kind of referred to the stuff we're talking about today in terms of sexual harassment as like sexual misconduct. There's now a very specific definition of prohibited Title IX sexual harassment. That's the language that we use for Title IX. And the federal regulations have very specific definitions of Title IX sexual harassment. We can break this down into basically three kinds of Title IX sexual harassment. First, severe, pervasive, and objectively offensive sexual harassment, which I already alluded to. Title IX sexual harassment also includes what we call the VAWA, or the Violence Against Women Act crimes. So domestic violence, dating violence, sexual assault, and stalking are still Title IX conduct. And then finally, a particular kind of quid pro quo. So, quid pro quo is like, I'll do this for you if you do that for me. And we'll talk a little bit more about that in a moment. So Title IX includes quid pro quo sexual harassment by an employee, but does not include sexual harassment by like a student on student. So that's kind of narrowing that scope that I just mentioned. Next slide, please. In terms of scope, uh, when we talk about Title IX, we talk about a complainant who's alleging that something bad happened to them, and a respondent is the person who has alleged to have engaged in the misconduct. So now the Title IX conduct has to have occurred within the United States. It is important to note that even that misconduct that occurs outside of the US can be covered by other policies, handbooks, codes of conduct at institutions. It's just not considered Title IX anymore. Second, conduct must have occurred within, for us, an Iowa State University program or activity, a program or activity of that institution, and that's also more narrowly defined in the new regs. And then finally, in terms of who could file a complaint, who would those complainants be? Complainants have to be current students or employees of the institution, or have to be currently seeking to participate in education or work in that institution. So big picture, in the end, conduct that is no longer under the Title IX umbrella can still be remedied and addressed at institutions. It would just be under policies and codes of conduct other than an institution's Title IX policy. Next slide, please. So what does this look like in terms of investigation and adjudication at institutions? So again, this is really big picture, but see, these are some of the major changes that we are all addressing. First, when we think about sexual harassment, folks often do not want a formal resolution. And we'll get to this by the end of our conversation today. Oftentimes, folks who are experiencing sexual harassment want an informal resolution. They want to be heard. They may want a conversation. They want the issue to be addressed without it being formal. Under the new regs for Title IX, there has to be a formal complaint first before there can be any kind of informal resolution. Importantly, there's no longer any kind of informal resolution where an employee is alleged to have engaged in conduct against a student. So the new regs are very clear that when there is an allegation that an employee is engaging in misconduct against a student, that has to be a very formalized process. Second, all parties and their advisors have a right to inspect all evidence. Under the new rule, every party to the proceedings has the right to an advisor. And at Iowa State and at the other institutions, parties have always had a right to kind of have a support person, one or more support people go through the process with them. Under the new regs, the role of advisor serves a very important function because there is now a live hearing that is required as part of the Title IX process. And the function of those advisors at the live hearing is to serve as a questioner. So this is really a new model, both in terms of what the advisor is, what that role is, and what that live hearing might look like. Prior to the new regs, there had not been a requirement for a live hearing. The new regs say that there must be a live hearing in which the parties are able to see and hear each other. They do not have to be in the same room, but it has to be live and they have to see and hear each other. And again, each party must have an advisor to serve as that questioner because the advisors cross-examine the witnesses to the investigation, the witnesses to the matter, and the other party. The live hearing is overseen by a hearing officer who makes real-time relevancy determinations during the hearing. All parties and witnesses have to attend that live hearing and submit that live cross-examination led by those advisors. Any statement that is submitted by a witness who doesn't attend that live hearing has to be excluded from consideration regarding a finding about responsibility. So these are pretty substantial changes. And it's interesting as we're going through the process at Iowa State, we have not yet gone through an investigation because these new regs just were implemented on August 14th. So we can kind of anticipate and theorize about what this is going to look like, but it's hard to describe it because we haven't gone through it yet. And I know that that's the same for other institutions as well. Next slide, please. So now let's turn our attention briefly to Title VII, another federal law that prohibits discrimination in employment on the basis of sex, race, color, religion, national origin. The Equal Employment Opportunity Commission is the agency that enforces Title VII. And what's important about Title VII is this is the law that's very applicable in employment. So at Iowa State University, for instance, There are plenty of cases that are Title VII around employees, and Title VII is very different from Title IX. Title VII, when we think about the prohibition against employment discrimination, we're talking about all kinds of stuff, right? So recruiting, hiring, promoting, transferring, training, discipline, discharge, work assignments, work performance measures, and the provision of benefits. All of those things are included in Title VII. Next slide, please. So when we're talking about Title IX sexual harassment, it's different from, I'm sorry, when we're talking about Title VII sexual harassment, it's different from Title IX. And in higher ed, we're going to have to really kind of navigate this. Like, how does Title VII and Title IX play out on our campuses? It's just going to be different. And a case could be both Title VII and Title IX, or it could be one or the other. We're going to have to see how this works out in real time. Two main kinds of Title VII sexual harassment, and this applies to all employees in the workplaces. A quid pro quo under Title VII is a situation in which a person with an apparent authority demands participation in some kind of sexual behavior in return for some benefit or to avoid detriment. I'm a little tongue-tied, I apologize. So it's like where a supervisor says, if you do this, then you get to participate. Then you get to have that kind of benefit. And the key is just an apparent authority. It does not have to necessarily be supervisor, supervisee. But that authority and the this for that is the key to quid pro quo. The second kind of Title VII sexual harassment is what we're familiar with as hostile work environment. And generally, we can define this as an unwelcome, sexually offensive conduct that is sufficiently severe or pervasive to create an intimidating or demeaning work environment. I would note that Title VII is codified in the Iowa Code as well. Next slide, please. So when we turn to Iowa Code, section 19B12, there is the following definition of sexual harassment. So again, I encourage us to be mindful about how when we're talking about sexual harassment, regardless of which law or policy or handbook that we're talking about, there are just these common threads, right, that we want to be mindful of. So in the Iowa Code, sexual harassment includes persistent, repetitive, or highly egregious conduct that is directed either at a particular individual or at a particular group that a reasonable person would interpret as an intentional harassment of a sexual nature. So that's key. We talked at the beginning about kind of intent versus impact. So here in Iowa Code, intent does matter. Taking into consideration the full context in which the conduct occurred and threatens to impair a person's ability to perform their employment duties or functions normally within their institution. Next slide, please. Then when we turn to Board of Regents policy, for instance, we can look at two things, employee handbook and the board policy manual. So all of this is just, again, to draw your attention to what are we talking about when we're talking about sexual harassment. When we look at the employee handbook, first we would note policy 13, which is the sexual harassment policy. So it includes that Iowa Code definition that we just went over and discusses quid pro quo, sexual harassment, and hostile environment. Policy 8 regarding office conduct and decorum also talks about unwelcome and severe or pervasive and objectively offensive and substantial interference. And we're going to go over all of those kinds of prongs of sexual harassment in a couple of minutes. When we look at the board policy manual about sexual harassment, again, we see references to the Department of Education, EEOC, the ICRC, Iowa Code. It all fits with what's in the board policy manual. Again, reference to hostile environments and this notion of an unreasonable interference with employment or education. So we can see what's common to the sexual harassment regardless of what policy or law we're referring to. Next slide, please. In all of these, when we talk about sexual harassment, the question is what makes it sexual harassment? Again, for it to be harassment, it has to be based on actual or perceived protected status, right? So for example, if someone is targeted based on wearing a collared versus uncollared shirt, or if someone is targeted because they're in biosystems engineering versus mechanical engineering, that's not harassment because those categories aren't protected status, right? So when we're talking about sexual harassment, we're talking about discrimination harassment on the basis of sex. So the conduct we're talking about is usually going to be of a sexual nature, which could be verbal or physical or nonverbal or visual. We'll talk about that in a moment. Again, there's this theme that it needs to be severe or egregious or pervasive or persistent. So either it's a really, really bad kind of conduct, or it's something that's very, very frequent happening over and over again. And those can kind of intermingle in a way we'll talk about in a moment. And then this third prong is this impairment of the individual's, the person who's targeted, of their ability to access or to perform in the workplace or in their education. Next slide, please. So oftentimes as in equal opportunities, we're talking to folks about sexual harassment. You know, it's very helpful to think about what do we mean by sexual, by severe, pervasive, and offensive. And we can kind of think of it in the terms of the spectrum, and there's all these balancing outs, right? So perhaps one act that's super egregious but only happens once could constitute sexual harassment. And it could be the case that some conduct that on its own doesn't seem that bad, but if it happens over and over and over again, the scales are weighted such that that could be sexual harassment. So just for clarification, I think it's helpful to go through what we mean by these terms. So sexual conduct can show itself in so many different ways. I think we often think about the physical, right? Someone touching. Oftentimes, you'll hear there are cases in which someone's being rubbed or being caressed, or somebody's touching them, touching their side, or patting them. It can also be a blocking of movement. But oftentimes, that sexual conduct is not physical. It can take the form of comments, right? Commenting on someone's appearance, commenting on how somebody should appear, commenting about someone's sexual history or sexual behavior. It can be jokes, it can be innuendo. Requesting dates over and over again can constitute sexual harassment. Rumors can also be sexual conduct, and it can also be problematic if someone knows about sexual rumors, for instance, and doesn't try to stop them. In terms of nonverbal, when we're talking about nonverbal sexual conduct, like the scan, where somebody looks someone up and down, right? Or if somebody's staring at intimate body parts, that's like a nonverbal kind of sexual conduct. Or gestures, or even sounds can be nonverbal conduct. And then we also see visual. So if somebody has a certain screensaver, showing someone certain images on their phone, right? Posters, photographs, that kind of stuff can all be sexual conduct. When we're talking about severe or pervasive, even though it's like, or something could be severe enough that it wouldn't have to be pervasive, and something could be pervasive enough that it wouldn't have to be severe. So when you're thinking about, for instance, verbal, if someone makes a one-time comment about someone's sexuality, that's probably not going to be sexually harassing. But if it happens over and over and over again, and in that way it's pervasive, that's when it could become harassment. Similarly, a one-time touch that is sufficiently egregious could constitute sexual harassment, even though it only happened once. So when we think about severity, like how severe is the conduct, like a touch, how severe is that? We think about, is it distressing? Is it threatening? Is it intimidating? The key is that it not be trivial. So the law is clear that it can't be merely a trivial act. Pervasiveness. Here we're talking about how frequent is the conduct. Is it repetitive? Is there a pattern? Is it generalized? Does it happen over and over again? The key regarding pervasiveness is that it not be isolated or sporadic. So you can see it's kind of this balancing, right? Whether we're talking about physical or verbal, the egregiousness, the severity, and its frequency is kind of the balancing act in sexual harassment assessment. And finally, when we're talking about offensiveness, like something being objectively offensive, first of all, we use that reasonable person standard that we just mentioned when we were talking about Iowa Code. And by offensive, we mean, is it vulgar? Is it derogatory? Is it shaming? Is it belittling? The last thing I would say about this slide is that we can note that power dynamics often do play a role in this, right? Power dynamics play a role. It's important to note that someone does not have to be of a particular sex or gender identity or sexual orientation. That doesn't matter. It could be any one of those, and it could still constitute sexual harassment. And importantly, it could be someone who is not in the workplace, but is a vendor, is a third party, and that can also constitute harassing behavior in the workplace. And finally, I would add that when we're talking about sexual harassment, it doesn't have to be the victim who's experiencing the sexual harassment. Bystanders, other folks who are witnessing the conduct can also be harassed. Next slide, please. So when I said it's kind of like this spectrum or this balancing act, I just wanted to share with you some examples of what that looks like. So if you imagine you're in the workplace and your supervisor touches you once on the shoulder, right? That's not going to be sexual harassment. Touches you every time you interact, that's more problematic. If they touch you once on your buttocks, well, a one time isn't bad, but it's the buttocks and it's a supervisor. So that kind of complicates it. And touching you repeatedly on the buttocks would probably be sexual harassment, right? So those dynamics matter. Similarly, if you take the example of a colleague tells you you are impossible to work with, well, that's not going to be sexual harassment. But if they call you a bad word, a gendered word, but immediately apologizes and never does it again, maybe not. But what if they call you a really offensive word once? That could be it. And if a colleague frequently refers to female coworkers as a negative gender term, then again, that's more likely to be sexual harassment. So you can see how this plays out. Next slide, please. So here's a scenario. Imagine you're a supervisor. Your employee tells you that they have been sexually harassed by a colleague. The situation that they describe to you does not sound like sexual harassment. It seems like the employee is too sensitive and is making more out of the situation than what it really is. Next slide, please. So as you're navigating that kind of situation, first, the power dynamics do matter. If it's a colleague reporting to a supervisor versus a colleague reporting to another colleague, that's a consideration. But it's important to remember a few things. It's when we receive a report from someone that they feel like they're being sexually harassed in the workplace, it's important to not make presumptions because the person might not be sharing all the information that they have, nor do they have to. And it's not necessarily, if you're not in the role of investigator, it's not your job to investigate that, right? You have to follow your appropriate reporting procedures. So the Board of Regents has very clear reporting procedures. If you have a concern about harassment, you report it to a supervisor. And if you need to, you can go up to the executive director, right? So that reporting structure is super important. Sharing of resources is very, very helpful as well. And it's really important to maintain privacy. So oftentimes what we'll see in different departments, different units, when stuff happens, people are likely to talk about it, to tell other folks about it, let people know. And sharing that information can be really problematic. It's important to maintain privacy, to follow the procedures, and to report. And then those folks who are assigned responsibility for addressing these things can go ahead and do so. Next slide, please. So in this scenario, you have an administrative assistant who tells you that they've been having problems with the individual who's been delivering packages to your office. The delivery person has been repeatedly asking them out on dates and frequently touches their hand, shoulder, and side. Note first that the sex, gender of the parties does not matter. And we talked a moment ago about, well, what if it's a vendor, right? This isn't somebody who's in the workplace doing the behavior. This is the person delivering the packages who seems to be having a negative impact on the administrative assistant. Next slide, please. So again, something like this could be a hostile work environment because it's having that impact on the employee and could be impeding their ability to do their work. Harassment, again, can occur by any party. So it could be a vendor, a third party, it could be a supervisor, it could be a supervisee, it could be a colleague, it could be somebody in any position of power or in any status within or without the workplace. Again, you would want to follow the appropriate procedure for reporting and have that trained person go ahead and do the investigation or do that follow-up. And oftentimes interim measures are available. So in a case like this, it could be worked out that that particular person doesn't do the deliveries to the office anymore. So part of the importance of sharing, reporting to the appropriate party so that they can do those steps to make sure that employees are safe and free from harassment within the workplace. Next slide, please. So when we talk about responding, and this can be in terms of either a person who feels that they are being harassed, or it can be in terms of someone who knows or has heard about harassment, there's basically three main kinds of responses. Non-responses, what I would call informal responses, and then formal responses. So non-responses, and these are very frequent, can be just ignoring it, right? So someone keeps asking you out or making comments or touching, and you just don't do anything about it. You choose not to report and you leave it alone. Sometimes folks will just leave the employer when they're experiencing the misconduct and do that without telling anybody why. There are very good reasons why folks don't report. We see this in our work all the time. We need to be honest about the impact of reporting, right? That if you feel like you're being harassed or discriminated against, you can very reasonably fear retaliation. You can fear people spreading rumors about you. You can fear that nothing will happen. You can fear that something's going to happen. So people have good reasons for not reporting. Informal responses include things like confronting the person who's doing the harassment, and bystander intervention. The prevention strategy we use at Iowa State is called Green Dot. And so those folks who work in bystander intervention strategies will often talk about the Ds. So things like delegating, seek assistance, delegate to someone else to address the situation, documenting. If it's happening, you can write it down, take photos, capture what's happened to you. Distracting, if something problematic is happening, distract to intervene in that behavior to make it stop. So if someone's telling really offensive jokes in the office, you can tell them to stop. You could distract them to stop it. You could document it and report it to a supervisor. Those are the kinds of things we mean by informal responses. Informal responses are helpful because if you don't do anything, if you ignore the behavior, whether it's happening to you or to somebody else, it's just going to keep on going, right? And that's not better for the individual or for the workplace. So we've got that category of informal responses. And then we've got formal responses. And when we're talking about harassment and discrimination, what makes something harassment or discrimination is that it's on the basis of protected class and it's codified in law, which means there's some kind of a legal remedy. So formal responses are usually those legal remedies. So, filing a complaint with the Equal Employment Opportunity Commission, filing with the Indiana Civil Rights Commission. Formal is also going to HR, going to the supervisor, going to the executive director, and filing that report in order to get the process started. Other formal responses are hiring an attorney or seeking a civil suit. So what we would hope is to encourage folks to be able to offer an informal response and follow the procedures, right? So at Iowa State, we have, I think, a very well codified process for reporting. And same thing, it's very clear with Board of Regents that there's a codified procedure for addressing these things, and it's important to do so in order to get them to stop. Next slide, please. So when I think about what our responsibilities are, when we talk about harassment and who the harasser is, it could be anyone. Someone can be harassing somebody and it could be unintentional. You don't mean to do it, but we need to be very mindful and practice situational awareness, right? To just be aware of, are folks saying or doing things that could really be negatively perceived by someone, that could be perceived as harassing with those criteria that I gave you before, right? And we can kind of assess our spheres of responsibility for risk factors. So especially if we are in a supervisory position, to really be mindful of potentially sexually harassing situations or behaviors. We need to set an example of appropriate conduct, right? Be mindful of our jokes and our comments and our physical and other behaviors. Recognizing that harassment can happen anywhere by anyone, and really conveying that harassment is a community concern. It's not an individual concern, it's about the community, because harassment can harm the whole workplace. We need to take complaints very seriously. and provide multiple channels for reporting and for support. It's helpful to disincentivize or to incentivize appropriate action and disincentivize retaliation, for instance, right? Because if someone feels like it is safe to report to their supervisor that they're being harassed, and then harassment and retaliation is taken very seriously and people see that, they're going to be more likely to report. And finally, I often think about mapping related policies as well. So, for instance, in Board of Regents, both in the handbook and in the policy manual, there are different sorts of policies that overlap. So you've got the sexual harassment policy, harassment and sexual harassment, and you have like non-discrimination statement. But we also have things like office decorum and use of regent property. So these are different kind of overlapping procedures such that if it's not sexual harassment, but is this other kind of bullying or threatening behavior that's still having an impact, it can be addressed. For instance, at Iowa State with Title IX now, since Title IX has kind of narrowed what those Title IX sexual harassment definitions are, what's covered by Title IX, we can still address and remedy the behaviors that are problematic through other codes of conduct and other handbooks. So we've been really diligent about finding all these different ways to address concerning behavior, even if it isn't sexual harassment. All right, Brock, I think that's my last slide. It is. And I'm on time, 40 minutes. So thank you so much for listening. I'm sharing here some resources for more information. So ICRC and the EEOC have very helpful information about sexual harassment, but also discrimination and harassment in general. AAUW has good resources, as does the National Women's Law Center and LENA.org about what sexual harassment is. And again, just giving resources around discrimination and harassment. I'm so grateful for your time and your attention. Thank you so much. I welcome your thoughts and your questions at this time. And Brock, if you don't mind on-screen sharing, if that's okay, just so I can see folks a little bit better on this end, that'd be great.
Adrian, this is Jim Lindenmeyer. I had a question on your slide number 9 with regard to Title VII in federal law. I noticed those protected classes don't include age or sexual orientation. Is that still accurate? Or
that's an excellent question. So yes, Title VII has those 5 narrow categories, but states are able to expand. So when you looked at the slide that was like Iowa code for all our protected classes, it's far greater than federal law. So states have the right to expand, and municipalities can as well. So Iowa has a very expansive list of protected classes, but you're correct. Note though, Jim, that when we're talking about sex, that does include sexual orientation and gender identity currently. So EEOC in its enforcement does acknowledge both of those as kind of covered under sex.
Thank you.
Absolutely.
Are there any other questions for Adrian? Okay, well, thank you so much, Adrian. We really appreciate it.
Thank you. I appreciate your time. You all take care.
It's good. Thank you.
Thank you.
Very good. Thank you.
Thanks.
Very good.